Ratio Fundamentalis Institutiones Sacerdotales numbers 119-2201. And also in the Catechism of the Catholic Church number 2358. It is in the light of this that we are gathered here as future priests and teachers of faith and morals. To help us steer these affairs, we call upon our brother, Mr. John Opomba, as the chairperson and assistant.
Conscientiously to this lecture, devoid of any fear or bias, and seek clarification when the need be. On this note, the rector, Monsignor John Opomba, the Dean of Seminary, Father Gregory, Father Thomas Francisco, the Seminary Parish, our guest speaker, brothers and parents, ladies and gentlemen, I bring you to your notice that my co-chair and I are ready to accept and act the capacity of the co-chair and chairperson respectively to steer the affairs of this lecture. Thank you.
Thank you. To introduce the main guest speaker, I would want to bring to your notice some people who have joined for this program. We have Betty K, who is the secretary. He came with the main speaker. Madam, welcome. We have also Sewa, who is a law student, who also came with him. Welcome, Sewa. Now, he hails from Kumasi in the Ashanti region of Ghana. He attended the University of Ghana for his Bachelor of Law degree and the Ghana School of Law for his professional qualifying certificate in legal practice at Ghana School of Law, Makola, before being called to the Ghana Bar in 2003. He subsequently proceeded to the University of Kumasi degree and Doctor of Philosophy degree in law, respectively. He is a senior lecturer at the Faculty of Law here in University. He is an ardent senior lecturer in law at Lancaster University, Ghana campus. His research
Thank you, MC, Mr. Chairman, Mr. Associate Chairman, Director, Committees, distinguished Reverend Fathers, Seminarians, brothers and sisters. I'm happy to be here tonight to share some few thoughts, as you say, to raise issues which need those who prefer non-heterosexual activity. The church, for that matter, every human being should love them, but you may disagree with the act, which is legitimate based upon a particular moral constituency and belief system we are coming from. So, I'm not here to be judgmental as whether the LGBTI is good or bad. As analysts, as Christians, we know where we stand. But I'm here tonight to speak more as a legal philosopher, as someone who has interest in the interface between law and philosophy. And for that matter, the current issue, which is of interest to entire humanity, not only those of us in Kumasi or Ghana. So the topic, as advertised, is the LBTI in Ghana, an exposition and critique of the promotion of proper human sexual rights and Ghanaian family values, 2021. Now, in terms of our discussion, after a few words of the introduction and the background, just to make sure that all of us are on the same page regarding matters which have actually brought us to where we are, I will give a brief insight into legislative process, which are the antecedent to the current situation. And then we would like to have a global view, some kind of an appreciation of what is contained in the bill. Of course, we have the bill, and if you don't have a copy yet, I can leave the copy with you and you can read a little, but we'll just tease out some aspects for our discussion. And then I will also bring up fundamental issues or the difficult issues which come up when you look at the bill, or what are some of the puzzles that the bill actually provokes. In terms of the general philosophy of the bill, as well as the specifics. And again, we also remind ourselves that the scope of sexual orientation, sexual preference, is not new, and as students of philosophy and theology, you know it all too well. However, as a student of jurisprudence or legal philosophy, you will remember that the relationship between morality, sexuality, and law is a contested territory. And we've all seen the famous heart-deviling debate following the major effort by the English society to decriminalize homosexuality after the Second World War era. So we will briefly look at that, because that should provide a very useful context which can help us to think through some of the issues which come up as far as the promotion of proper human sexual rights and Ghanaian family laws is concerned. And again, we will, time permitting, take a very quick comparative law perspective, try and look at a few selected African countries and look at how they have actually dealt with the issue of non-heterosexual activity. And I will ask the question, how can we keep our African identity and at the same time remain friendly to other cultures? So maintaining your identity and remain open or remain tolerant to other cultures who are not Africans. So that is a very tight rope which we need to work on, and we see how we navigate that. And then the multi-million-dollar question is that in the light of all these Mila-Balo controversies, what is the way forward? Should we allow the bill in its current formulation as pending before Parliament to pass and eventually assented by the President? Well, when we get there, I would like to reiterate what the Constitutional Review Commission encouraged in 2010, except that maybe I would like to have a bit of tweaking. The Constitutional Review Commission wanted us to leave the issue to the Supreme Court to interpret. But recent events have actually made all of us become convinced that the issue of legislating on LGBTQI++ is not a matter which can sensibly be left to just the cause alone. We need to build consensus as a society, and then we come up with a well-informed position which will respect all significant issues that need to be addressed. So, Mr. Chairman, in a nutshell, that is a roadmap on basis of which I proceed to have this discourse with you. So I will try and not keep be too scripted, but in order to display my talking, I will also try and keep to the script. So we see how we marry the two. So LGBTI and its related activities, Mr. Chairman, as we know, is one of the most discussed subjects at the world stage, the global level. It's not only in Ghana, except that it's now that we are waking up to that debate. Now, while the subject of LGBTIQ+ and its related activities is not a talking point in some organizations within the African continent, it has become the headline of frontline papers in recent times in Ghana, following the introduction of a bill by Honorable MP for Igbo Pram, Honorable Samuel Nate George, which bill seeks to sound a dead candle, or if you like, to effectively uproot LGBTIQI+ and its related activities from Ghana. Now, prior to the recent discussion, the subject of LGBTQI+ and its related activities flashed the news, generating public opinions and expert discussions. If you have to do a simple Google search, LGBTI Ghana, you had at times so many news items or so many blog articles and so on will come up. And the quantum, in terms of the numbers, have actually been astronomical the last few days. Simple reason, the introduction of the bill, which is pending before Parliament, and that also provides, I think, the reason for we being interested to actually look at it. And the epic, which wrote in January 2020, when the Center for Popular Education and Human Rights, a pro-LGBTIQ+ organization, opened its first office in Accra. And the organization aimed to advocate and advance the cause of LGBTI community in Ghana, and that provided the euphoria which we all witnessed regarding whether we should embrace LGBTI or we should completely say no to that. Now, unfortunately, the office was created by the National Security Force, as we know, in the late February 2021, and this led to the heightened discussion and advocacy among constitutionalists and human rights experts on the need for Ghana to recognize the rights of the LGBTIQ community. They argue, among others, that the non-recognition and the treatment of the community is a constitutional aberration, as it is discriminatory, making reference to Article 17 of the Constitution. And for that matter, it constitutes a fundamental departure from the tenets of the Constitution. And they argue further that the non-recognition and treatment of the LGBTQI+ community in Ghana is also a serious affront to Ghana's international treaty obligation. Ghana is a party to the African Charter on Human and People's Rights. Ghana is a party to so many international instruments, including the International Covenant on Civil and Political Rights, International Covenant on Economic, Social and Cultural Rights, Universal Declaration of Human Rights, just name it. And all these obligations, according to those who are pro-LGBTI community, These instruments create obligation on Ghana to create a space for them to also exist and operate like heterosexual or those who do not belong to their sexual orientation and preference as it were. Now, aside this, we also notice that while political leaders, including even the President of the United States of America and other respected leaders, call on our President to take steps to recognize the rights of LGBTQ+ community in Ghana. And as a point, in fact, the rise in advocacy for the recognition of the rights of LGBTQI+ community in Ghana has breathed a deep antipathy and disillusionment among the Ghanaian populace. A survey conducted by Center for Democracy and Development, CDD Ghana, reveals that 93% of Ghanaians are intolerant towards advocacy and the eventual recognition of LGBTQI+ and its related activities in Ghana. Now, while this persists, on 2nd August 2021, the Promotion of Proper Human Sexual Rights and Ghanaian Family Values Bill 2021, which in this discourse we'll be referring to as the bill, was tabled before Parliament for deliberation. The bill has received support from major religious communities in Ghana, the Islamic community, Office of National Chief Imam, the Christian community comprising Catholic Bishop Conference of Ghana, the Charismatic, Christian Council, Pentecostal, and Orthodox. They've submitted memorandum in support of the bill, which seeks to oust completely LGBTQI+ and its related activities from Ghana. Now, their unflinching support for the bill stems from the need to hold in esteem the wisdom of Almighty God regarding human creation and Ghanaian cultural and traditional values. Now, be that as it may, legal luminaries and renowned constitutional and human rights experts have expressed their dissatisfaction and disenchantment towards the bill. And we know that the leading thinkers and lawyers, Kutuampao, my own good friend, Kutuampao, and then Professor Kwasi, Prempe, among others, Professor Tukuba, are heralding campaign. I'm not talking about the Tukuba who spoke here some time ago. Who spoke here some time ago, he is Justice Tukuba, the former Justice of the Supreme Court. But the Tukuba, this one is a Professor Tukuba. He is the Dean of the Faculty of Law, University of Ghana. Of course, he's also a former Seminary. He was my senior. Now, their case is that, contrary to the known view that the field of being LGBTQI is not a medical dysfunction. Rather, the field of being an LGBTIQI is right, which must be recognized and protected. They also hold the view that the bill undermines basic human rights guaranteed by the 1992 Constitution. And further, they argue that human right is paramount to everyone's existence in modern society, key to participatory democracy, and thus the value and cultural systems of Ghana cannot inhibit individual human rights. At the international front, United Nations independent expert on sexual orientation and gender identity, known as Michelle Victor Madrigal-Bolos, has expressed the view that the bill is a recipe of violence. According to Mr. Bolozo, the draft bill establishes a system of state-sponsored discrimination, torture, and violation against LGBTQI+ persons of great magnitude. Now, he noted that, given that the LGBTI people are present in every family and every community, it is not very difficult to imagine how, if it were to be adopted, This legislation will create a recipe for conflict and violence. Of course, this is the position by the UN expert on sexual orientation and gender identity. They've not been tested as whether they are true or not, but that is what it says. Now, adding their cards to the campaign against the bill is the Amnesty International and also International Coalition of Gays and Lesbians, who have also expressed similar concerns about the bill, that the bill buries to a very great extent the enjoyment of fundamental human rights and opens the door to the shrine of violence and ill treatment of LGBTQI persons in Ghana. In this paper, or this discussion, we will be providing a brief exposition on this bill currently before Parliament. And following this introduction, the next part will discuss the legislative processes that will lead to the passage of the bill into law. And then in part 3, we provide an overview of the bill. And this discussion will be literally into looking at the objects and contents of the bill. Then in part 4, the discussion will focus on the fundamental issues arising from the bill. Then drawing on international law jurisprudence, part 5 will examine the scope of sexual orientation and preference. And of course, that will look more at legal philosophy bit of the matter, which is very important in taking an informed view on the current debate. And the penultimate part will look at the part 6 will look at comparative discussion on anti-LGBTQI+, drawn from selected countries in the African continent. And then the penultimate will look at how we can keep our African identity and remain friendly to other cultures. And the conclusions for the way forward. Mr. Chairman, permit me to briefly highlight legislative processes leading to passage of the bill. In Ghana, the power to make law is undoubtedly vested in Parliament, as we see from Article 93 of the 2022 Constitution. Now, even so, the legislative power of Parliament is procedurally regulated, and Article 106 of the Constitution. And Article 106 stipulate the processes that must be followed before passing any law, any bill into law by Parliament. And for that matter, the current bill before Parliament is no exception to this constitutional procedural requirement. So the legislative processes commence with the publication of a bill, which eventually will transform into an act of Parliament. So a bill is simply a draft of proposed law. So a bill such as the current bill we are discussing must be accompanied by an explanatory memorandum. Explanatory memorandum explaining the basis for the bill, the philosophy for the bill, the justification for the bill, what mischief is the bill seeking to cure, and all that. So all these must be stated in the explanatory memorandum. That is why, if you get the bill itself, if you look at the PDF version, notice that a good number of pages have been devoted towards the memorandum, trying to contextualize it, the background, and what is precipitating the bill, and what the bill is seeking to achieve. Now, when the bill is introduced in Parliament, at least 14 days after it has been published in the Gazette. So there must be the publication in the Gazette before it's introduced. And the Gazette, as we know, is the official mouth speak, through which the state communicates to citizens in the whole world. And is the basis for the maxim that ignorantia non-legibus non excusat. Ignorance of the law is what? It's no excuse. If something is put in the Gazette, it's assumed that everyone knows about that. Now, when the bill is introduced in Parliament, the clerk or the presiding officer will read the title of the bill, and this is known as the first reading. After the first reading, the bill is referred immediately to the appropriate committee of Parliament. If you go to Parliament, you have standing committees, and they mirror the division of the ministries or the government portfolios. So depending upon the particular thematic area the bill relates, then after the first reading, the bill will be referred to the appropriate committee, and we call that the committee stage. And it's a committee stage that most of the detailed works will be carried out. And then the committee may involve the public in the process, including what we have witnessed, memorandum being sent by various interested individuals and groups to let their viewpoint be known to the lawmakers, so that they will factor all those things into their discussions and calibration before they send their report to the plenary session of Parliament. Yeah, they can even hold a public hearing. They can conduct public hearing. They come to like a town hall fashion. You have this bill you're looking at. These are the key issues. What do you think about these issues? You listen to the public and you take notes, and you let that shape how you go and rework the bill. Because a bill is just a work in progress. A bill is work in progress. So the promotion of proper human sexual rights and then the Ghanaian family values bill in this present constitution is not final. It's not final. Before it will eventually receive the endorsement by members of Parliament, a lot of changes might have taken place. There could be a lot of training here and there in order to accommodate various conflicting positions. And I think that communication is that which is not coming out well. And I think that our Parliament needs to do more in terms of letting the public understand the lawmaking process. Because communication is important. A lot of people, as soon as they hear about the promotion of proper human sexual rights, the Ghanaian Family Values Bill, they think that whatever is in the bill, every letter, every comma, every punctuation is going to come out just like that. No. Unless Parliament decides to just rubber stamp everything. Otherwise, in reality, a lot of changes can take place based upon the consultation, based upon the debates, based upon the memoranda which are received. So that is how it is. But so those who manage the process will let the public understand that. So at this committee stage, as I have indicated, members have the opportunity to make proposals for amending the bill. So maybe you say, okay, clause 2, I think that this word there should be removed, should be replaced with this word. You made the note. So eventually, it will be attached to the report, it will be sent to the plenary session of Parliament, and they will consider it as whether they should amend the original clause to reflect the suggested one, and so on and so forth. So that is how it is. So there will be debates on the acceptance or rejection of the committee's report, and that will take place at what we call the second stage of the bill. So the first stage, it just read the long title. So the long title of this bill, and now to provide for proper human sexual rights and Ghanaian family values, prescribe LGBTQ+ and related activities, prescribe propaganda of advocacy for promotion of LGBTQIAAP+ and related activities, provide for the protection of and support for children, persons who are victims or accused of LGBTQIAAP+ and related activities and other person and related matters. So this is a long title. So it is only this which will be read during the first reading. And after this, there will be no debate really. It's just referred to the appropriate committee, as I've explained. So the appropriate committee will go and do all the detailed work, listen to the public, receive memorandum, and then make their recommendation as to changes that need to be effected. And the changes, proposed changes, will be included in the report to the entire House. Then when the the report goes there, the bill will go to what we call at the second stage. So the second stage will actually be like a debate regarding acceptance or rejection of the committee's report. So the members of parliament will debate that as whether the report should be accepted or should be amended and so on and so forth. And at this stage, the principles and rationale of the bill, as well as the defects the new bill is meant to cure, are discussed. You don't just say you are making a law. What is the purpose? What is the problem? What is it that the existing law is not able to address? For which reason you want to make a law? So what are your proposed solutions to address the current defects in the law or the lacuna in the law, as the case may be? Now, this is then followed by consideration and then the third reading stage, or the third stage of the consideration stage. And this is the stage where the whole members of parliament will discuss the bill in details. Now, the bill will have taken shape. The reports have come, we've discussed the general principles and all that. So at this stage, the debate of the bill will be carried out clause by clause. So that is how law is made. So the speaker or whoever is presiding on that day will call clause 1. Clause 1 is there, all of them have copies. And we take ration of members. If you want to make arguments with it, you do that. After listening, then you take a vote. You can take a vote on that. Should this stand as it is? As many of you as will say aye. As many of you as can say no. Then you pick it like that. Then you go to another clause. That's what I call the consideration stage. You consider every bit, every detail of the so being an MP is a lot of work. It's not just how we say it. It's a lot of work. But they have to go through all that. So when the consideration is done, the various changes have been made and all that. Then the motion, a motion will be made for the bill to be passed, meaning that there should be a vote to approve it. The vote can simply be ordinary votes count, or it can be raising up of hands, or it can be what we call a secret ballot. One by one, every person will go and cast them. And I think that if you have a very sensitive and seemingly controversial legislation, it is prudent for every MP to take a responsibility. Instead of doing what we call like the voice count, to allow every MP to take a responsibility by coming to vote as a person. So that at the end of the day, we can even know those who voted for and those who voted against. We can even go a step further if you wanted. We need to know who voted what. Because the MP, as part of the campaign, we were able to say that I voted against this, the passage of this law. It should be part of, if you go to the US, I mean the lawmakers, that is how they actually campaign. But of course, we are still at the various stages of development, so we talk more about physical things. But they will say that, yes, I introduced this law, or I passed this, and I passed it. So it's all part of it. Now, following the endorsement or the passage by Parliament, the Act will be sent to the President for his assent. If the President has no reservation about the Act, he will right away append his signature to it. He will say that the bill has received presidential assent, and the bill has become law now. In terms of commencement, that is when it becomes operational, it will very much depend upon the Act itself. Sometimes a date for commencement might have been provided. A bill might have been signed by the President but may not start being effective immediately. A time might have been prescribed, or a minister might have been given the power to bring an airline to indicate when the bill is commencing. So it very much depends upon how it is worded. But whatever it is, we need a presidential assent. On the other hand, where he has reservations, he doesn't want to sign, he can make a referral, he's supposed to make a referral to the Council of State. And then the Council of State will look at it and then advise him and all that. And before you consider it again, of course, when there's a deadlock or stalemate, you can get the Parliament to override presidential veto if they have the requisite majority to test of all MPs. Now, the point to note is that in Ghana, most of the bills are expected to come from the executive level. But if you look at the law, MPs on their own can initiate legislation through private member bill. And the current bill we are talking about is an example of what they call the private member bill. Private member in the sense that it's not the government of the day, it's not the sitting, it's not the executive, which is introducing that bill. Some MPs, and I think if you read the memorandum, they let us know there is a bipartisan. Bipartisan means that it's not only either NPP or NDC or CPP, but what they call a cross party, that is people from various sides are coming together. But it's still a private member because it's not coming from the government. And that's why we call it like a private member bill. But the problem with private member bill is that it's very expensive because usually if the government is sponsoring a bill, the bill will have to go through a number of processes. Either a research work might have been commissioned, and maybe a detailed consultancy research work might have been commissioned on a particular issue. A report is made, it's probably reduced into policy, it's piloted for a while, a lot of consultations are done, then it is reduced into a bill. It goes to cabinet for the senior government officers to debate it and all that, before the cabinet will arrive at a decision that we want this bill to be introduced to Parliament, and then it will start its journey through the legislative processes. So you notice that a lot of things might have gone on, and most of the things only require money. But you need to do meetings, you need to do research and all that. But private member, unless you have some stakeholders, maybe some people who are interested in the particular bill that you are making, and they are providing the resources for you to do the necessary research, for you to do the necessary consultation and all that, so that you're able to build the critical mass of support. Because if you don't build that critical mass of support, the bill can easily be defeated. Who is in charge of Parliament? We have what they call the majority leader. The majority leader is the leader of government business on the floor of Parliament. So he is like, even like in your class, we call the class dean. So he is like the dean. He prepares the timetable in terms of how do you call the other paper. What are we going to discuss? What bill are we going to be working on and things like that? So if the bill is a private member, he can decide to give it little or no priority, isn't it? And it may never go through the full process. So for private member bill, you need to build that popular appeal. Just like what you are seeing with this current bill, proper human rights and Ghanaian family values bill. Try to build that weight of public opinion. So that way, it cannot just get lost in Parliament, despite the fact that it's not sponsored by the government, but it's sponsored by bipartisan lawmakers, as it were. But we have evidence that this is not like the first time that we have like a private member bill. If you look at the Frederick Ebert Foundation, for example, did the work, and their work they indicated that one MP called Mr. Lee Okan, who was an NDC MP, sponsored a bill, and that bill was supposed to be what we call the measures to remove algae in marine waters. So he came from the Dumoro district, and according to him, there was a need to remove the algae in the marine waters of the Dumoro district, which were affecting the livelihood of the people. So at least that's an example of another private member bill before the current one that we are all too familiar with. But unfortunately, the motion died prematurely due to lack of support. So if it's a private member, you need to build the support. Because if you don't get significant support, it will not be, there are a lot of activities Parliament need to do. So it will not be given prominence. So that is, so it died. Now, as I have indicated, undoubtedly, the well-known LGBTQI plus related bill currently pending before Parliament is a quintessential private member bill. And being a private member bill, of course, we cannot appreciate that it's not benefited significantly from the resources and the rich engagement and scrutiny and refinement. And no wonder maybe there may be one or two problems, maybe drafting difficulties. And of course, sometimes the rush with which it's done cannot affect the quality. But the most important thing is that I think the philosophy or the bigger principle which the bill is seeking to legislate, I think is what has actually received popular support. But in terms of the nuances, the details, that can be worked out and refined. As I indicated, there is no finality. It's just a bill. It will go through processes. And I've been monitoring the Speaker of Parliament ex-cathedral pronouncement that he is going to ensure that the bill is giving transparency in terms of the various discussion and so on. So all of us will be watching and then we'll see what is going on. Mr. Chairman, we would like to have a brief overview of the bill itself. Now, we have talked about the long title, and then the long title simply refers to the purpose of the bill. And if you look at the Interpretation Act of 2009, the long title is very much important aspect of the bill because whenever there are interpretive issues, maybe issues of ambiguity or issues of the proper scope of the particular law, applicability and all that, you need to interpret it. You will draw inspiration from the long title, but the long title is the purpose. To give you an idea, what is the purpose of this law? And there's what we call the modern objective and positive approach to interpretation. And that means that how you catch the long title is very important. Of course, if you look at the long title that I quoted from the bill, we get the idea, the purpose of what the law is trying to do, but there may be some question marks in terms of whether it is adequate or it's not adequate. For example, if you look at what I quoted, the objects to provide for proper human sexual rights and Ghanaian family values, fine, then you understand that prescribe LGBTQ rights and related activities, prescribe propaganda of democracy, propaganda of advocacy for or promotion of LGBTQ, like that long abbreviation, and plus then, and all that. So the question is, what is the purpose of the plus? The purpose of the plus to say that, well, apart from the subtle and known heterosexual activity, any other deviation or any other thing apart from heterosexual activity, so long as it has anything to do with sexuality, that is what you mean by the plus or what. So those are some, of course, they have interpretation session. If you look at the bill itself. Then the bill in this interpretation clause, and of course, if you look at the memorandum, it makes the point that unlike other other bills which are passed into the Parliament, in most traditionally what is done is that we have the interpretation clause towards the end of the law. But in this particular one, the interpretation clause is really at the beginning. And if you read the memorandum, they make the point that because of the strange terminologies, strange abbreviations, acronyms, taxonomies and whatever, which are being used, That is why at the very early stage, we need to explain the concept of what we mean by the various, and that is why we have the interpretation in the very early stage. So we look at the clause 2, it defines proper human sexual right as the right of a person, A, with binary sex categorization of male and female assigned at birth. And this is very important because most of the things that we are witnessing in this debate is a question of whether your gender is it fixed when you are born or is subject of change based upon an election which a person will make. And if you make such a free choice and a change, should society, for that matter the law, respect the change in your gender, or the law should not respect that? Because as far as society is concerned, as whether you are male or female is a binary issue. Binary issue means that it's either or. Two things. You are male or you are female. And that is determined when you are born. From birth, when we see that, oh, it's a male, that's it. All your life until you die, you are male or you are female. But the LGBTQIAAP plus community would like us to also look at the other side, that it's possible for the gender to also change. So these are some of the things that we have to address our mind. So at birth, to the physical, emotional, psychological well-being and enhancement, healthy growth and development of the person, especially where the person is an adolescent or youth. So we say proper sexual human behavior, proper sexual human rights. These are the things that at the time that you are born, either you are male or female, and you exercise that as was determined at birth for your physical, emotional, psychological well-being and enhancement. And then your healthy growth and development as a person, especially where the person is what? Is an adolescent or youth. And also to positive educational and institutional materials, activities and actions. And for me, this is the crux of the matter. The crux of the matter is that it's not so much, very soon I'll be referring to the case of R.M. Brown, and some judges will say that what adults do in the privacy of their closet is their own choices. But then, the advocacy bit, but what makes it more complicated. Can you embark upon education, especially to younger persons who are not coming up, so that we let them understand that when it comes to human sexuality, it is not just heterosexuality. We also have various versions of homosexuality and all that. Or should you wait for the child to grow, so that when the child grows, he or she will then find out and then will make the choice? I think that is an aspect of the current controversy going on. Should we allow free discussion so that those who are not even adults will hear about it, and so on and so forth? But Mr. Chairman, we will say a few more words about that as we move on. Now, family values is also defined to include respect for sanctity of marriage as a lifelong relationship between a man and a woman, each of whose gender is assigned at birth. You know that the law said that promotion of Ghanaian family values. So when we say family values, what do you mean? So that is what we saw as sponsoring the law is telling us. And then two, the recognition of nuclear and extended family as the basic unit of all Ghanaian ethnic communities. And this is very important. The nuclear family and extended family, based upon gender which is fixed at birth, male, female. Now if you go to some jurisdictions where they have recognized same-sex marriage and all that, there's this concept we call composite family, so that family is not just maybe what we know as maybe like heterosexual couple, children, and so on and so forth. But it's also possible to have same-sex couple and a child they might have had either from adoption or from some deployment of IVF procedures and all that. So, but the lawmakers and those who are sponsoring the bill, they are saying that you do not want to make any mistake regarding what we mean by Ghanaian family values. The Ghanaian family values include the recognition of nuclear and extended family as the basic unit for all Ghanaian ethnic communities. And two, the ultimate purpose for the role of government in protecting and advancing the family as a unit of society is to safeguard and promote the best interests of children. So they've introduced another important concept that, yes, the government has a responsibility to ensure that family life thrives. It's not just thriving for thriving's sake. It's thriving for safeguarding and promoting the best interests of children. And if you look at the Children's Act, we'll be told that in considering any matter relating to a child, the best interest of the child shall be of paramount importance. And that is what the sponsors of the law are trying to say. So I will urge you to look at the clause 2, and then you get all the various definitions that they have talked about. And again, Mr. Chairman, if you look at clause 3 of the bill, it imposes a duty on every citizen, in particular parents, guardians, teachers, religious institutions, organizations, the arms of government, the media and creative arts industry, and relevant independent constitutional bodies to promote and protect human sexual rights and Ghanaian family values as defined above. So we've not just defined this, I think that a conscious responsibility is also being thrust upon all and sundry based upon the categories of persons and entities that are elaborated, that we have a responsibility to also propagate this meaning or understanding of proper Ghanaian family values. And of course, this brings to my attention what we call the cartoons, right? Those who watch the cartoon, that is another area. Depending upon how the ongoing debate is resolved. If the debate is resolved that we want to maintain what has originally been Ghanaian understanding of expression of sexuality is heterosexuality, or we want to maintain what has originally been Ghanaian understanding of the nuclear and extended family, male and female and children. Assuming the debate concludes that way, then we may also need to be interested in what we call the content of television, especially now that we have the digital satellite television, the DSTVs and the various cable television, as well as the internet. Because if you study the cartoons now, the cartoons have been reprogrammed, and in a very subtle way, a powerful education is being made that you have to be open to more ideas than the conservative notion of the heterosexuality. But it's done in a very subtle way that you need to be a little bit more observant and with a little bit more sophistication before you will understand the cultural war which is going on. Especially so when the LGBTQI issue has not been resolved in Ghana and is still ongoing, so we don't know how it will end. Now, clause 4 goes on to prohibit persons from engaging in acts that undermine proper human sexual rights and Ghanaian family values, as provided for in the bill. So this is specifically to be done by refraining from instigating, commanding, counseling, procuring, soliciting, or purposely aiding, facilitating, encouraging, or promoting, whether by a personal act or otherwise, either directly or indirectly, any activity that undermines the defined proper women's sexual rights and Ghanaian family values. And this is what, it is this one which is making significant reverberations and then sending the ripples all over the world. That if you look at this way of putting it, what it means is that anybody who consciously or unconsciously, as it were, will deviate from discussing, helping people to live in the heterosexual way, in a way, is going to be guilty of what? Of an offense. Yeah, so that is, and it doesn't matter that you are not doing it yourself. Even if you are a landlord and you rented your room you let your room to someone who belongs to or someone who does not practice or who does not profess heterosexuality, then, according to clause 4, you are committing an offense. Because you have created a space for the person to live, isn't it? Yeah, so that is, that. And even, when it comes to even selling of food, probably if you know that someone openly, the person is known to be like the LGBTI person, and you are selling food to the person, you are going by the person's wedding. An argument to be made that you are encouraging him because you get the food to eat, you get energized, and I'm able to do that, isn't it? So that is problematic. And that is why I said that the group of academics and other people, we are not doing their debate here, but for me, I think that what needs to be emphasized is that the bill is not final. The details will have to work out. And as I said, there can be subtractions and what? Additions. But it's the bigger principle. And that is what the debate should be. The bigger principle, do we want to legislate on this? Before we go on to say that what should go into the law and what should be taken out of the law. But how the discussion is going on, those who are for and those who are against, I think that they've all taken a very extremist position, a very intolerant perspective. And I think that is not the way that it should go. Of course, when it comes to our various religious and moral consequences, we know where we stand as far as our faith is concerned. But speaking as a participant in the legal system and also as a scholar, I will say that we need to have a broader engagement and objectively and dispassionately look at all the issues. Mr. Chairman, if you look at the clause 5, it imposes obligation on the person in whose presence an offense specified in the bill is committed to report the commission of offense to the police, or in the absence of the police, the political leaders, opinion leaders, or personal leaders in the community. So if you know that a landlady or someone is doing anything to help another person who is not a heterosexual but is an LGBTQI, you have to go and report the person who is helping you to the police. And if you don't do that, your failure to report such a crime is also what? A crime. So that is the problem. And then you see that, Mr. Chairman, if you look across the 6 to 11, the bill essentially ban LGBTQ plus related activities and make them criminal offenses. So various offenses are created. So clause 8, for example, a person commits an offense if that person engages in sexual intercourse between persons of the same sex or between person and animal. But then, what is even sexual intercourse has also become a contested issue. There are some scholars, some commentators, who will say that now if you talk about sexual intercourse, it's not just what is traditionally understood as the penile penetration of the female vagina, we need to know that there are so many aspects, and I came across an article by Raymond Tukuba in which he makes the argument that if you talk about our Criminal Offences Act having actually criminalized unnatural carnal knowledge, it does not appear to address the full spectrum of what would be considered LGBTQ plus activities, because if you look at the Criminal Offences Act, it talks about unnatural carnal knowledge, and unnatural carnal knowledge has been understood in contradistinction to natural carnal knowledge. And with respect to the law of rape, natural carnal knowledge is understood as the penile and then the vagina or the vulva. But so if that is the case, the natural carnal knowledge is the penile and the anus. And if you put that away, there are some other forms of sexual expression. So how do you bring them within the equation that we are talking about? And that is why clause 6 to 11 is actually providing for so many things. But Mr. Chairman, it is important that we also look at these clauses that are just banded together. But of course, our time will not permit us. Suffice to say that they prohibit a person from marrying or purporting to marry a person who is of the same sex as that person or holds out as lesbian, gay, transgender, pansexual, a queer, a pansexual, ally, a non-binary, or any other sexual or gender identity. That is contrary to binary categories of male and female. So, it doesn't matter. We are not talking only about gay or lesbian. No. Any other sexual orientation, preference, you cannot marry that person. If you did that, that should not be recognized as marriage. And various offenses and various punishments have been prescribed for those offenses. And then, Mr. Chairman, if you look at the clauses 12 to 16, the proscription of propaganda of advocacy for promotion of LGBTQIAA+. Now, that is where the crux of the matter is. So, clause 12, for example, provides that a person who, by use of media, technological platform, technological account, or any other means, produces, procures, markets, broadcasts, disseminates, publishes, or distributes a material for purpose of promoting an activity prohibited under the bill, or a person uses an electronic device, the internet service, a phone or any other device capable of electronic storage or transmission, to produce, procure, market, broadcast, disseminate, publish, or distribute a material for purposes of promoting an activity prohibited under the bill, commit an offense, and is liable on summary imprisonment, summary trial, for a term of imprisonment of not less than 5 years and not more than 10 years. So what it means is that you are not supposed to do anything in terms of sharing information with another person concerning any of the prohibited sexual activities under the bill. And even having a discussion on the radio or TV and all that, they are all serious offenses under the bill. Now, clause 13 prohibits propaganda, promotion and advocacy activities directed at children in relation to the activity prohibited under the bill. So, if you have any program which is meant to let children be interested in LGBTQ activities and all that, that is serious offense. That is serious offense. So, if you are using, because according to the memorandum that they did the research and noted that some children are lured with gifts and so on by some LGBT community networks operating from outside the country. And that seems to have informed this particular clause. And again, clause 14 prohibits funding or sponsorship for prohibited activities. So if we also provide funding let's say that I'm coming here to speak to you, just like even the kind of discussion I'm doing, because I have been taking a very firm position as this way or that way. That can be interpreted as doing LGBT advocacy. So, if somebody provided funding for me to come, that is an offense. And that's what clause 14 is talking about. And then clause 15 says to disband groups or societies, association, clubs, or organizations existing before the coming force of the bill, whose purpose, overt or covert, are wholly or in part to promote, facilitate, support, or sustain in any way, and not prohibited under the law. So you have some club for society, which is to promote or encourage LGBT activities and all that. They are all prescribed. Now, if you go to some countries, I know in Britain, for example, they have what they call like the gay villages. The gay village. So the gay village means that that particular place, maybe they have like the pubs and other things there, and only gays and lesbians go there. So when you go there, what it means is that either you become one of them, or you have friends among them and you want to visit them or something like that. But here, what this law means is that you cannot even have that. You cannot say that, this drinking sport is LGBT. That is a serious offense. Now, Mr. Chairman, there's an interesting aspect of and that's the last bit of global, that is provision for protection. And that aspect is not also discussed well in the ongoing debate. Provision for protection of and support for children, persons who are victims or accused of LGBTQIAAP+ and related activities. So if you look at clause 17, for example, the court is empowered to refuse an application for an adoption order. If you want to make an adoption, if you want to apply for adoption, and if the court gets to know that you are a lesbian or you are gay, bisexual, transgender, transsexual, queer, an ally, pansexual, intersex, the court will refuse the adoption. In other words, clause 17 is discouraging LGBTI couple from adopting a child or from fostering a child. If you look at the clause 19, you cannot also foster a child if you are an LGBTI. So these are some of the things. So let's say that if you are taking, let's say that if LGBTI couple from another country come to Ghana that they want to adopt, now the social welfare people will need to do investigation and all that. But let's suppose they are coming from a country where LGBTI is legalized. You will not get cooperation from the authorities in that country because over there is not illegal. So if it's not illegal, why should it become a subject of inquiry for you to make a decision as whether you allow them to adopt or you don't allow them to adopt? Now, in the light of this general appreciation of what the bill is about, in the term, some pertinent or fundamental issues arise. And as I indicated, the bill in its present formulation certainly provoke fundamental issues which should not be treated lightly and ought to be given informed and dispassionate consideration within the context of our society, which is confronted with pluralism of normativity. Pluralism of normativity in the sense that we, of course, as Catholics, remembering St. Paul II's teachings on the relativism, that we are living in a time where people deny moral absolutes, that everything is what is relative. And all those things, because we are living in a society in which we are not all Catholics, we are not all Christians, we are not all Muslims, we are not all traditionalists. People have, even in Christianity, because look at the Anglican Church, for example. If what we read on the BBC is true, that Archbishop Volbeck, that is the Metropolitan Archbishop, like he has even waded into this debate, isn't it? Trying to say that they should exercise caution, otherwise they will unnecessarily be discriminating against LGBTI people and so on. So that tells you how the issue of pluralism of nativity is, where we are confronted with whether we have, is there anything like a subtle moral or normative standard? So that is the issue. So first, Mr. Chairman, I have suggested that the bill, when passed, will infringe the fundamental human rights guaranteed under the Constitution and plethora of international human rights standards. And for that matter, some people view the bill as what they call the ad hominem legislation which is directed at certain persons, and that it's not good to do legislation directed at specific person or group of person. Secondly, does the 1992 Constitution permit all choices that a person may exercise in the spirit of liberalism, which is a hallmark of Western democracy? And this is one key issue which I am flagging, that yes, is it the case that the 1992 Constitution, having regard to Chapter 5, fundamental human rights and freedoms, that yes, we have liberties and all that. Now, that liberalism doesn't mean that you can make any choice at all. Those are some of the big issues we need to think about. And for example, if you look at Article 33 of the Constitution, the Article 33 clause 5, it creates the sense that the human rights embodied in Chapter 5 of the Constitution, and for that matter, the Constitution, are not exhaustive, and that other human rights, which are not explicitly articulated in our constitutional tablet, but are enjoyed in some other democracies and are considered conducive to democratic dispensation, are also considered as part of our human rights regime. Now, if that is the case, can we say that then that provides a window of opportunity for embracing LGBTQ+? Then thirdly, does the constitutional injunction in Article 26, which outlaws cultural practices that are dehumanizing and injurious to physical well-being of a person, sufficiently elastic to encapsulate outlawing of homosexuality and its variant forms? And this is very important. If you look at Article 26, it says that cultural practices which are dehumanizing and physically injurious to a person are prohibited. Now, if that is the case, can we say that the various forms of sexual expression within the spectrum of LGBTQ+, can we say that they're on the same pedestal as those cultural practices which are considered as injurious, dehumanizing? Can we validly make such an argument? Can we say that if someone is, for example, a lesbian, he is causing a physical injury to the other party or to himself or herself? Well, I don't have answers to this, but these are issues I want to raise. Or, if we take the game, I think the last Sunday, I happened to sit in the sermon of the Metropolitan Archbishop of Kumasi, Justice Gregory, and I think he devoted his homily to explain the LGBTQ+ matters. And one thing, of course, we can also know this, that especially, let's say, if you take like the game, for example, he made the point that if you look at the anatomical constitution of a person, it's consistent with anthropological observation that the male is made to give, and then the female is made to do what? Receive. So if, and you look at that, you said there were children, so you created an interesting analogy that we know that we eat food through the mouth. If I take our water through the mouth, if I came here and, Lawyer has been talking for a long time, give him water, please, water. As soon as I get the water, I open my nose. I start doing that. I'm sure that a lot of people scandalize, or I said, okay, boil the water. And then I pour the water through my ears. I'm sure you may take a video which may go viral. Should you put it on the social media? That this person said he was thirsty. But when we gave him the water, he drank it through the ears or through the nose. So he was using that analogy to say that when it comes to sexual activity, it is penis to vagina, not penis to anus, not penis to anywhere, or not vagina to vagina, not nothing. That is not how God made it. And if you are not even talking God, and we are talking about how the organs are, I'm recording this argument. These are not my arguments. I don't have any arguments of my own. Yeah, so that is the question. But Mr. Chairman, one big issue which I would like to draw our attention to is that can it be said that children are no longer entitled to paternalism from the law and society at large? Now, at common law, the law is replete with so many examples, instantiations of where children are protected paternalistically for obvious reason that they are inexperienced and they may be exploited by some unscrupulous of adults. So when they come to contractual transaction, the common law will say that if you are a child, if you are a minor, that is a common law, the age used to be below 21, but these days, if you look at the combined effect of the Constitution, the Interpretation of 2009, the Children's Act of 1998, the Companies Act of 2019, the Land Act of 2020, if you look at the combined effect of these legislation, you can validly argue that a minor is someone below the age of 18 years. So what that means is that a common law, if you are below 18, you are seen as being vulnerable and you need protection. So the question is, are we saying that children are no longer in need of this protection from the law? Because when it comes to children matters, then if you look at the children law or the children act, we are told that the welfare principle, the best interest of the child. Now if you are a child, you are growing up, you don't know, you haven't had sexual activity, but you observe what goes on in society, your parents and all that, and you see that, your mother is living with your father, and so on and so forth. So that is what you see. If you are going by the psychologists who say that your brain is like a tabula rasa, like the clean slate, and then whatever is in you is what you observe and empirically experience and all that. Now, I am suggesting, Mr. Chairman, that in terms of the gender, being male or female, which the sponsors of the law are saying that it is determined at birth, and that is actually what we are accustomed to. With respect to children, it should be seen in an analogic fashion as if you take a device, if a device comes from a factory, for example, if you get your phone, you buy a new phone. The phone has got settings, isn't it? And you call those settings the default settings. Now, later on, you can reconfigure the settings for your own specific functionality. So in my view, As far as, and this is the only matter I have my own personal view, which is not anybody's view, that as far as children are concerned, assuming Ghana resolved that we are embracing LGBT, assuming, I'm not saying we've done that, the law will need to be structured in such a way that children are not exposed to reconfigured factory settings. Is the default factory setting, if I say default factory setting, that is how they were born, their original biological dynamics. Those are the default factory settings. And because they are children, they are not experienced, they cannot make informed, rational choices. It's better for them to become adults, 18 years or more, and then they will have observed the world sufficiently, they will have understood their own selves and all that, before they can take responsibility for irrevocable sexual orientation, preferential choices, rather than having a system which will let the child, before he or she has become an adult, is giving information in which he or she will not be able to make like a better assessment. So I think that is one thing that we will need to look in mind. So, Mr. Chairman, Aguendo, it is submitted that the binary gender of male or female is what is assigned at birth, and for that matter, same will likely to default settings on the device imposed on it when it becomes a finished product, leaving the factory. Mr. Chairman, because we are students of philosophy, we will not actually conclude this discussion without looking at the scope of sexual orientation or sexual preference and re-emergence of the tension between natural law and legal positivism. The search for essence or nature of law has witnessed remarkable ideological and doctrinal clashes. Sexual orientation or preference is one side, where what counts for purpose of legal validity is seriously contested over centuries. Two schools of legal philosophy and jurisprudence are notable in these doctrinal tensions. Legal positivism basically postulates that what constitutes law is what has been posited or put forward by the one, that is the sovereign, who has power to make law. The sovereign is considered as having the ability or means to enforce his or her commands or wishes by progression. The Mebanta, John Austin, and Skelsen, and Hart, and to a limited extent, Ronald Joachim, are leading proponents of the classical and modern understanding of legal positivism. Natural law, too, on the other hand, maintains that nothing is worthy of validity as law, unless same approximate to certain high principles of morality, which are universal, immutable, and eternally valid. This school of legal philosophy has a long-standing scholastic tradition, spanning from the ancient Greek philosophers like Socrates, Plato, Aristotle, Christian thinkers like St. Augustine, St. Thomas Aquinas, classical and Enlightenment scholars like Provincial, Spinoza, social contrarians like J.J. Rousseau, John Locke, Thomas Hobbes, J.S. Mills, and contemporary proponents like John Fuller, Devlin, and John Finnis. Now, as Cousin has noted, the links between law and morality constitute the subject matter of an age-old jurisprudential debate. And Mr. Chairman, the following issues come up. Ought the law concern itself with morality? Ought the law to reflect shifts in public opinion concerning moral questions? Ought the law to intervene in order to prevent an individual choosing course of action, which moves him along the primrose way to bonfire. The problem of morality and the law emerged in Britain in an acute form in the era following the Second World War. There was an absence of concern prompted by highly publicized criminal trials of homosexual offenders, an appearance and sale of literature of a sexually explicit nature. It was suggested in some quarters that the restraints imposed by law in the name of morality were no longer effective, and that the disintegration of the social fabric was not far off. Public concern hastened the appointment of a royal commission to investigate patterns of homosexual offences and prostitution. Unhappily, for subsequent debates in jurisprudential inquiry, the phrase morality and law seem to have been narrowed down to sexual morality and the criminal law. Now, there's a report we call it the Waffenday report, the report which emanated from this debate. So the report of the Committee of Homosexual Offences and Prostitution, known as the Waffenday report, appeared in 1957 and recommended changes in the law. Some of the recommendations became the basis of the UK's Sexual Offences Act 1967. But, Mr. Chairman, let me reiterate that Waffenday's report is quite crucial, and I'll say monumental, in the sense that for a long time, if you look at our Criminal Offences Act, the law against unnatural carnal knowledge and all that, these laws were actually transplanted from English law. And at that time, English law was based heavily on Judeo-Christian moral philosophy. And that was why, in one case called High and High, one judge called Lord Penzance said that marriage is the union between a man and a woman to the exclusion of all others. Now, this was a classic definition Lord Penzance in Hyde and Hyde in the early part of the 19th century gave regarding marriage. And that definition should actually let to appreciate that at that time the law was actually premised upon Judeo-Christian moral compass. But as I have just pointed out, following the Waffenday report, they had a new law on sexual offences, and it sought to decriminalize certain homosexual practices. In other words, homosexual practices were not going to be completely outlawed. If it happened in private, for example, that is tolerable. That was like the new position of the law. And of course, that in itself also generated significant debates, producing viewpoints which tended to polarize arguments, which Professor H. Early had, and then Sir Patrick, and later on became Lord Devlin, a former Justice of the English Court of Appeal, made. Now, what was the philosophy of the Waffenday report? The Waffenday report is based upon two main theses or ideas. First, the function of criminal law in relation to the subject area of the inquiry, that is the sexual offences, was to preserve public order and decency, to protect the citizen from what is offensive or injurious, and to provide sufficient safeguards against exploitation and corruption of others. And two, unless a deliberate attempt is to be made by society, acting through the agency of the law, to equate the sphere of crime with that of sin. So let's be attentive. To create the sphere of crime with that of sin, there must remain a realm of private morality and immorality, which is in brief and good terms not the law's business. So Waffenday report was trying to say that we shouldn't have what they call a monolithic view of morality or unidimensional view. We should see morality this way. We have private morality and private immorality, so to speak. And according to the Wolfenden report, essentially, that if society is not trying to put crime and sin on the same pedestal, then private morality and private immorality should not be concerned of the law. So that is the the crude statement of the thesis of the Wolfenden report. Now, as I indicated, this Wolfenden report, which sought to essentially decriminalize homosexuality, generated an interesting legal philosophical debate between Professor Hart and Lord Devlin. One supported it, the other did not support it. Now let's quickly state Lord Devlin's position. Now Lord Devlin's position was based upon 3 questions, which he asked and he sought to provide answers. First, the first question was, has society the right to pass judgment at all on matters of morals? So that was his question. Has society got the competence to decide on what is moral and what is not moral? Second question, if society has the right to pass judgment, has it also the right to use the weapon of the law to enforce it? So it's for a logical progression of ideas. If society has the power to determine morals, then since society uses the law as an agency, as an instrument to achieve social engineering, can it also use law to fulfill this responsibility of making pronouncement on what is moral and what is not moral? Then the third question he posed was that, if so, ought it to use that weapon in all cases or only in some? And if only in some, on what principles should it distinguish? He was trying to say that if you agree that society can pronounce on morality, then society can use law, then in all situations in which society will need to pronounce on whether something is moral or not, must it use law or it must pick and choose? If it must pick and choose, so there are some matters it's not going to use law, on what basis are you ignoring some? On what basis are you saying that the society should use law in making pronouncement on morality of all things as it were? Now, of course, his answers were in the positive, that yes, society has the power to determine what is moral and what is not moral. And then he also agreed that society must use law or may use law to preserve morality. So he also answered that question in the affirmative. Now, for the third question, as whether that should be done all the time or we should pick and choose, Lord Devlin made the point that it is necessary to discuss how society's moral judgment ought to be ascertained. So reference should be made to judgment of the right-minded man, not necessarily the reasonable man. So he's creating a distinction between reasonable man and the right-minded man. He can be thought of perhaps as a man in the jury box, like when you go to the court and you're having a trial, like the jurors there. So that is the right-minded man. Or he can be thought of perhaps, so we said that let morality be considered as what every right-minded person considered to be moral. So to determine, of course, I think somewhere in our studies, we also hear that the voice populi voice what? Or voice Dei voice populi, something like that, isn't it? The voice of God is the voice of the people.
The voice of
God. Good. So somehow you see that lurking at the back of his mind that if right-minded, not reasonable people, right-minded persons, what they will consider as immoral should then be taken as what? Immoral. I mean, these are questions that we need to think through. We don't need to answer them here as it were. Now, Professor Hart disagreed with all these arguments Devlin had made in respect of the Wolfenden report, seeking to decriminalize aspects of homosexuality, and Hart made the point that what Devlin has told us is not sound logically, and made the point that there is no stimulus web of morality which should be turned beyond repair by individual sexual deviancy. So saying that if one person has deviated sexually, it doesn't mean that the entire moral fabric of society is going to be what? It's going to be turned ascendant. For that matter, what Devlin is saying cannot be taken as sustainable, logically thinking. Now, Professor Hart urges that consideration be given to disproportionate misuse, which result for the individual convicted for sexual misdemeanor. Somebody has indulged in a sexual misdemeanor, a prohibited sexual act. The person is thrown into jail. Why? For having a sexual desire and which is exercised in a manner contrary to that prescribed and recognized as legitimate by society. The person will be languishing in jail. Now we should consider the disproportionate misuse which such a person will suffer. So how warns legislators, lawmakers of the dangers of using as a criterion for legislative action the disgust produced by deviant behavior in the mind of the right-thinking man. This can lead to condoning of intolerance. And he makes the point that if you are talking in democratic terms, we have a special risk, and that risk is that the majority may dictate how all should live. So what we call that the dictatorship of what? Of majority. So that is another risk. That, okay, so if you take Ghanaians, for example, as we stand here now, I'm sure that if you are to do a survey, probably you may get 20% or closer to that, who may say that we shouldn't even waste time in talking about whether we should provide any accommodation to any form of those having sexual deviancy or whatever. So let's say we are left with 10%. That is the minority. Are they entitled to accommodation? Are they entitled to legal protection? So those are some of the issues which Professor Hart is trying to remind Devlin and his followers. But Mr. Chairman, before I end, the case of R.M. Brown is a case which we need to remind ourselves, because the issues at stake there will help us to think critically and dispassionately about some of the issues at stake. And this case is not too old. That's decided by the UK House of Lords in 1993. And the R.M. Brown is an interesting case. What was it about? It's a case in which 5 men had been convicted for their involvement in consensual, unusually severe sadomasochistic sexual acts, sadomasochism. There are some people, their pleasure sexually lies in pain, infliction of pain. They are okay, put me on the table and cane my buttocks with a lot of lashes. Then I'm sexually what? Satisfied. Yeah, so they have been indulging in this. They have been indulging in this severe sadomasochistic sexual act for over 10 years. So there was a very secret operation called the Spano Operation to investigate and then get to the bottom of it. And eventually, they were arrested, tried, found guilty, and convicted of the offense. Because the way that they were doing it involved nailing part of the body to a board. You nail me to the board, I'm deriving sexual pleasure. Nail. Not only that, and again, so many other things, like pierce that hot. You put a nail, a metal in the fire, and then you put it on the person and all that. Then the person is driving sexual pleasure and all that. So eventually, a referral was made to the UK House of Lords, and this was the question: where a person, let's say A, wounds or assaults another person B, occasioning him actual bodily harm in the course of sadomasochistic encounter, that is any of those weird inflation of pain to get a sexual excitement, does the prosecution have to prove lack of consent on the part of B, that is the person who was at the receiving end, before they can establish his guilt, that is the person who did it? Well, the House of Lords, there were 5, and there was a division. 3 said that even if you consent, if you give permission that yes, beat me, or use a metal to hit me, and that makes me sexually happy, it is still not permitted. So consent is not permissible for is a mouthful, isn't it? Sadomasochism, which will result in pain and an injury being created to the person. And 2 also disagreed, 2 dissented, and said that if consent is there, then so long as a temporary physical pain is going to let the person have some lasting sexual excitement, that should be tolerable. But just a statement was made, and I want to just quote a little bit of that. And then, now, Lord Templeman made the point that, quote, "It is not clear to me that the activities of the appellants were exercise of rights in respect of a private and family life. Society is entitled and bound to protect itself against a call of violence. Call of violence meaning that we form like a club, and for us all that we do, we inflict violence on each other for our weird excitement. Now, Lord Templeman was saying that society has a duty to protect itself against such type of arrangement or such type of association. Pleasure derived from the infliction of pain is an important thing. Lord Templeman speaking. Pleasure derived from the infliction of pain is an important thing. Cruelty is uncivilized. I will answer the certified question in the negative and dismiss the appeal of appellants against the conviction. So we're saying that cruelty is what? It's uncivilized. Now this was 1993. So the question is, can we say that what is involved in the various lesbian, gay, bisexual, transgender, transsexual, queer, allied, intersex, what again? There's another inter. What is another inter? Intersex, the intersexual or something. Yes. And the queer and all the variants. Can we say that they involve cruelty? Do they involve cruelty? So if they involve cruelty, can we say that according to what Lord Templeman is saying, society has a duty to protect the society and those who are the receiving end from that? Or you cannot say that that involves cruelty as well. Okay, Mr. Chairman, as I end, I want to say that, well, the time will not let us do the comparative exploration, but later on, those who are interested in reading the full paper, when I send it, you can read it. But the main question is that, how do you walk the tightrope? Can we keep our African identity and at the same time remain friendly to other cultures? If I say other cultures, we know that some places, some jurisdictions, they have legalized these LGBTI activities and all that. But then we know that as Africans, we have our long-held culture and tradition, which make us unique in a number of respects. For example, we are communitarian. We do things together. And what that means is that when it comes to sexuality, in Africa, when a man and a woman engage in sexual act, they are not just doing that for their individual selfish pleasure only. The man is representing the whole family. The woman is also representing what? The whole family. You need to have to read writers like R.S. Bradley and some of the African writers and all that. You will get evidence to support that. And that is why marriage was considered a serious one, a very serious thing. So, but if you look at the Western evolution of sexuality and sexual expression, is more based on the individuality. But we are still the communitarian. But over there, I think what is really important is the individual. So that is another thing that we have to think about. That are we still Africans or we are no longer communitarian? We have metamorphosed into the Western atomistic individual, so that we are no longer communitarian. If we are not communitarian, then it will be easier for some of these things to easily work out. But on the other hand, if we are communitarian, then it becomes a bit complicated how we actually navigate this entire route. And again, you look at certain sexual practices which were outlawed. For example, prohibition of marrying within a certain degree of consanguinity, proximate blood relation. You call it incest. That is not allowed. And if it is done, either you face capital punishment or you are ostracized, because the fear is that the anger of the world of deity will be triggered and there will be reprisals visiting upon the living. And because of that, there was some kind of sexual code, isn't it? Yeah, so these are all part of the Africans that we are. But living that, it is also a fact that we are not living on our own. We are living in a global village. We all travel and we go to places where they have legalized some of these things that we are talking about. And we cannot change the law over there. If they are coming to Ghana, if for example someone is also a same-sex couple for let's say 10 years, and for work reason, he or she will need to come and work in Ghana for some time, are we going to say that because we are Ghanaians, Africans, and we haven't legitimized that, the person should ignore the partner or wherever that he or she are living with and come to Ghana? So these are some of the issues that we need to think through. That's why I said that let's be more critical than being just emotional. And finally, what is the way forward? Mr. Chairman, as far as the way forward is concerned, I will urge Ghanaians to go back to what happened in 2010 when we set up the Constitutional Review Commission. And thank God I was a member of the research, I was in charge of Ashanti region. I went through all the districts. And I held this type of town hall meeting for DEBA. And we raised issues. And if you look at the report, it's even available on the internet, the Constitutional Review Commission report 2010. If you look at paragraph 117, I think up to paragraph 128, those areas, they deal with the issue of the recognition of lesbian and gay rights. That is how it was headed in the report. And paragraph 117, Mr. Chairman, simply says that the sole dimension of the issue of gay rights is whether or not the Constitution should give recognition to lesbian and gay rights in Ghana. So this was the issue which we presented to those who were interested in responding to the consultation. And then we received a number of submissions. And this is what some of the people said, paragraph 90 quote. The Commission received few submissions from persons wanting the Constitution to recognize the rights of homosexuals in the Constitution. This was 2010, only few said that we should do that. However, I'm still quoting, these are not my words. However, the overwhelming majority of the submissions were to the effect that homosexuality should not be recognized by the Constitution. So this is paragraph 119 of the Constitution Review Commission. Then paragraph 120, the submission received on the issue of lesbian and gay rights can be summarized as A, the Constitution should not recognize gay rights in Ghana for the gay prevents procreation, without which the society can become extinct. So Ghanaians were saying that because of that we shouldn't recognize it. The second reason too, culturally, it is an abomination to be lesbian or gay. The practice of lesbianism or homosexuality is alien to Ghanaian culture. 3. Even, I'm quoting, these are not my words. Even animals, these are not my words. Even animals, other than human beings, do not engage in such a practice. So humans should not. And these are all from paragraph 119 of the 2010 Ghana's Constitutional Review Commission report. Even animals other than human beings do not engage in such a practice, so humans should not. Ghana should not copy brandly from foreign countries. Ghana should not copy brandly from foreign countries. Homosexuality will not bring development to our society. So 2010, Ghanaians were saying that homosexuality will not bring development to our society. Maybe now it can bring, so that is VI. Homosexuality is against the laws of nature. VII, I'm just quoting. Homosexuality is against the laws of God. God, in his own wisdom, made us for purpose of procreation. We should therefore resist demands from unscrupulous Ghanaians to accommodate depraved sexual tendencies. The Constitution should recognize lesbian and gay rights for the following. So this is the other side. Those who said that it should be recognized, you are the people I coming to now. 1. A man should have the freedom to live with his fellow man, if that is what pleases him. 2. Some people are born homosexuals and should not be allowed to should be allowed to express their sexual orientation. Then paragraph 121. There were other submissions which described as inaccurate, generally accepted position on section 104B of Act 29, that is the Criminal Offences Act. Because it's based on assumption that natural carnal knowledge means having sex via the vagina, and therefore having sex by any other means amounts to natural carnal knowledge, even if it is with one's spouse. So these were the issues the Commission received. But the Commission notes the submission and made the following observation. And I'll go to the recommendation because of time, the findings that the Commission made. So paragraph 123, the Commission finds that during its consultation, the overwhelming number of submissions received on the subject was in favor of non-recognition of the right to sexual orientation for homosexuals. 124. The Commission finds that in recent times, gay and lesbian issues have taken center stage in Ghana. 125. The Commission finds that in any case, it will be neither necessary nor advisable for the Constitutional Review Commission to attempt to deal with this complicated issue at that time. Yes, I'm very aware, but this is very important. To deal with, this is why I came, to deal with this complicated issue at this time. It is very probable that a proposal to give some recognition to same-sex relationship in Ghana at this stage will be condemned by a large section of the population in the country, mainly on religious and cultural grounds. On the other hand, a suggestion to introduce a provision in the Constitution expressly excluding same-sex marriages in Ghana will be clearly seen by many people in the country and outside of it as a reactionary move, not going of a progressive state. Unquote. So, in a nutshell, all that they were trying to say was that we are not going to put expressly in the Constitution that in Ghana, when we talk about marriage, there's only man and what? Woman. Or there's nothing like other. Because the Commission was afraid, and that was the only thing, that if it did so, Ghana is afraid of being blacklisted. That Ghana will be put on the list of countries which are not progressive. So because of that, the Commission did not recommend that we should amend the Constitution and put it explicitly there. On the other hand, the Commission recommended that we should leave it to the Supreme Court. So if you go to the 128, the Commission finally finds that the above argument notwithstanding, there does not appear to be any compelling reason for the Commission to address, let alone attempt to deal with this issue in the present context. This was 2010. The more advisable approach would seem to be to leave the matter for settlement by the Supreme Court in due course. If and when there is enough interest in the matter and there is a sufficiently strong feeling about the issue, those who wish to promote the idea will be able to seek an opinion from the Supreme Court, and the court will be soberly and its own time consider the submission put before it and issue the interpretation of the Constitution in the light of the strength of the argument advanced. In doing so, the court may also seek to take account of prevailing conditions and views in the country at the time. Good. So this is from the Constitutional Review Commission in 2010, telling us that, well, there's no time for us to legislate or to amend the Constitution to reflect that. If anybody is worried, let the person go to the Supreme Court. For the Supreme Court to tell us whether LGBTIQ or lesbian, gays and all that is recognized under the law within the human rights culture or is not. But as we speak now, there is no authoritative pronouncement by the Supreme Court on the matter. And we have to keep thinking about this, and we shouldn't be afraid to keep thinking about all the issues which have been raised objectively, not in a very emotive way, but in a very logical, philosophical way. Thank you very much, Mr. Chairman, for the audience.